The Department of Justice just got caught red-handed doing something so shocking that even Speaker Mike Johnson is calling it unconstitutional. Federal prosecutors have been secretly tracking which members of Congress searched for Jeffrey Epstein files in classified databases. And when I say tracking, I mean logging every search, every timestamp, every keyword query that lawmakers entered while investigating one of the most explosive scandals in American history. This isn't some conspiracy theory floating around on social media. This is documented surveillance of elected representatives by the very agency they're supposed to oversee. Hit that subscribe button right now because the information I'm about to reveal will fundamentally change how you view government accountability in this country. So here's what we know happened. On January 28, 2025, a whistleblower inside the Department of Justice leaked an internal memo to the House Judiciary Committee showing that DOJ officials had been monitoring congressional database searches related to Jeffrey Epstein for the past 14 months. The memo, dated December 15, 2024, reveals a program called Operation Oversight Integrity that was allegedly created to track unauthorized access to sensitive case files. But here's the problem. Members of Congress aren't unauthorized users. They have constitutional authority to conduct oversight of the executive branch, including reviewing closed criminal cases when investigating potential misconduct or cover-ups. The DOJ didn't just monitor random searches either. According to the leaked documents, they specifically flagged searches containing terms like Epstein client list, flight logs, sealed indictments, and prosecution decisions. And get this, they created individual profiles for 23 different Congress members tracking their search patterns over time. When Speaker Mike Johnson was asked about this surveillance during a press conference on January 30th, his response was absolutely stunning. Johnson, who rarely breaks from measured Republican talking points, called the DOJ's actions a direct assault on the separation of powers. He stated on the record that no executive branch agency has the authority to surveil members of Congress conducting legitimate oversight, and he announced immediate hearings to investigate who authorized this program and why lawmakers weren't informed. This is the same Mike Johnson who has defended DOJ independence on multiple occasions, who has pushed back against claims of weaponization, who has consistently urged Republicans to focus on legislative priorities rather than investigations. When someone with that track record says the Justice Department crossed a constitutional line, you know something catastrophic just surfaced. Smash that like button if this is making sense so far, because what I'm about to tell you next is even more disturbing. Here's where the story gets absolutely wild. The leaked memo doesn't just show that DOJ tracked congressional searches. It reveals that prosecutors shared this surveillance data with senior officials at the FBI and forwarded reports to the Office of a Deputy Attorney General every 2 weeks, summarizing which lawmakers were most actively searching Epstein-related files. Sources who reviewed the complete documentation told reporters that one section of the memo explicitly discusses concerns about members of Congress potentially discovering information that could complicate ongoing sensitive matters. Translation: the DOJ was worried that elected representatives might find evidence of something the department wanted to keep buried, and they set up a surveillance system to monitor who was getting close. Now, let me be crystal clear about why this matters so much. Congress has what's called the Speech or Debate Clause in Article 1, Section 6 of the Constitution. That clause protects members from being questioned in any other place for legislative acts, which courts have consistently interpreted to include investigative activities. The whole point of that protection is to prevent the executive branch from intimidating or surveilling lawmakers who are doing their constitutional duty of oversight. If the Department of Justice can secretly track which representatives are investigating what topics, they can identify threats to their preferred narratives and potentially take steps to discourage or discredit those investigations. That's not how a constitutional republic is supposed to function. That's how authoritarian regimes maintain control over inconvenient inquiries. And here's where it really gets serious. When members of the House Judiciary Committee reviewed the full classified version of the memo in a secure facility on February 1st, they discovered something even more explosive. The DOJ surveillance program didn't just track Epstein searches in isolation. It was part of a broader monitoring system called the Congressional Access Accountability Initiative that logged all searches by Congress members and their staff across multiple federal databases, including classified intelligence archives, sealed court records, and FBI investigative files. According to 3 lawmakers who spoke to reporters on condition of anonymity, the program had been operational since October 2023 and had collected data on more than 180 members of Congress and approximately 400 congressional staffers. One Democratic representative who reviewed the documents stated that this represents the most serious breach of separation of powers I've seen in my 12 years in Congress. Drop a comment right now if you saw this coming, because I genuinely want to know your perspective. Here's what multiple constitutional scholars are saying about this situation. A Harvard law professor who specializes in executive power told news networks on February 2nd that if these allegations are accurate, the DOJ has violated fundamental principles that date back to the founding of the Republic. The executive branch cannot surveil the legislative branch's oversight activities without destroying the constitutional balance that prevents any single branch from accumulating unchecked power. A former federal prosecutor with 25 years of experience added that even if DOJ officials believed they had good reasons related to classified information security, the proper response was to work with congressional leadership through established notification procedures, not to implement secret surveillance of elected representatives conducting their constitutional duties. But there's an even deeper problem here that almost nobody's talking about publicly. The Jeffrey Epstein case isn't just another criminal matter. It involves allegations of sex trafficking that potentially implicated wealthy and powerful individuals across politics, business, and entertainment. The case ended abruptly with Epstein's death in federal custody under circumstances that still raise serious questions. Prosecutors made a controversial non-prosecution agreement in 2008 that shielded potential co-conspirators from charges. And despite years of public pressure, the full client list and complete flight logs have never been officially released. So when members of Congress search those files, they're not just satisfying curiosity, they're investigating whether the Justice Department properly handled one of the most significant criminal cases in decades, and whether anyone received preferential treatment or protection from prosecution. Stay with me, because what comes next will completely blow your mind. On February 3rd, Representative Jim Jordan, who chairs the House Judiciary Committee, sent a formal letter to Attorney General Merrick Garland demanding answers about Operation Oversight Integrity. The letter asks 17 specific questions, including who authorized the surveillance program, what legal authority DOJ relied on, whether anyone outside the department received the tracking reports, and why congressional leadership was never notified despite clear constitutional concerns. Jordan's letter includes a stunning detail that reporters initially missed. According to documents obtained by the committee, the DOJ surveillance system automatically flagged any search that combined Epstein's name with terms like non-prosecution agreement, flight logs to Caribbean, or names of prominent individuals. Those flagged searches triggered alerts that were reviewed by senior DOJ officials within 24 hours. Think about what that means for a second. A member of Congress sits down at a secure terminal to investigate whether the Justice Department properly prosecuted a sex trafficking case. They search for information about who might have been involved or protected. And within one day, senior DOJ officials know exactly what that lawmaker searched for and can take whatever steps they deem necessary to manage the situation. That's not oversight, that's intimidation. That's the executive branch keeping tabs on legislators to identify threats and neutralize them before they become problems. And if you don't think that chills legitimate congressional investigations, you're not paying attention to how power actually works in Washington. Don't go anywhere, because the most explosive part is coming next. Here's what makes this scandal even more outrageous. When Attorney General Garland was asked about the surveillance program during a Senate hearing on February 4th, he didn't deny its existence. Instead, he claimed that the monitoring was part of routine security protocols to prevent unauthorized disclosure of classified information. But here's the problem with that defense. Members of Congress have security clearances. They have constitutional authority to access classified information for oversight purposes. And there are already established procedures for handling concerns about potential leaks, including working with congressional security officials and the House and Senate Intelligence Committees. Creating a secret surveillance program that tracks which lawmakers are investigating what topics goes far beyond legitimate security concerns. It's political intelligence gathering disguised as information protection. And the timing of this program raises even more red flags. Operation Oversight Integrity reportedly began in October 2023, just weeks after several House Republicans announced plans to investigate the DOJ's handling of the Epstein case and demanded unsealed documents related to the 2008 non-prosecution agreement. A former senior Justice Department official told reporters that he couldn't recall any previous instance where DOJ implemented systematic surveillance of congressional database searches, and he described the program as highly unusual and almost certainly improper from a constitutional standpoint. The timing suggests this wasn't a neutral security measure. It was a targeted response to congressional scrutiny that DOJ officials wanted to monitor and potentially control. Subscribe immediately if you haven't yet, because this content doesn't exist anywhere else. Now, here's where Republicans in Congress find themselves in an impossible position. On one hand, many have spent years defending DOJ independence and pushing back against claims that federal law enforcement has been weaponized for political purposes. They've argued that Justice Department investigations should proceed without political interference and that congressional oversight must respect prosecutorial discretion. On the other hand, they're now confronted with evidence that the DOJ secretly surveilled their own members for investigating a case with massive public interest and clear oversight implications. Defending this surveillance means accepting that the executive branch can monitor legislative activities, which undermines the entire foundation of separation of powers. But acknowledging it as misconduct means admitting that concerns about DOJ overreach might have merit, which contradicts their previous positions. And here's the tricky part for anyone trying to defend what the Justice Department did. There's no good explanation that holds up under scrutiny. Either DOJ officials genuinely believed they needed to track congressional searches for security reasons, in which case they should have worked with congressional leadership through proper channels rather than implementing secret surveillance. Or they knew this was constitutionally problematic, but did it anyway because they wanted to monitor which lawmakers were getting too close to sensitive information. Neither scenario is defensible. Both represent serious violations of the constitutional balance between branches of government. Do me a favor and slam that like button, because it genuinely helps this video reach more people. Legal analysts are calling this a constitutional crisis that goes far beyond partisan politics. A former White House counsel who served under both Republican and Democratic presidents told news networks on February 5th that regardless of one's views on the Epstein case or the Justice Department's handling of it, the surveillance of congressional oversight activities cannot be tolerated. Once you accept that the executive branch can secretly monitor which legislators are investigating what topics, you've essentially destroyed congressional oversight as an effective check on executive power. A constitutional law professor at Yale added that the framers specifically designed the separation of powers to prevent exactly this kind of executive overreach. And if there are no consequences for DOJ officials who implemented this program, it sends a message that constitutional boundaries don't actually matter when politically inconvenient. So let's break down what this could mean going forward. First, the immediate political impact is enormous. Speaker Johnson has announced that the House will hold hearings starting February 10th with testimony from DOJ officials, the whistleblower who leaked the memo, and constitutional experts. Johnson stated publicly that he expects full cooperation from the Justice Department, including the production of all documents related to Operation Oversight Integrity and the Congressional Access Accountability Initiative. If Garland refuses to provide those documents or witnesses Stonewall Committee questions, it could trigger a constitutional confrontation between the legislative and executive branches, with potential contempt citations and court battles over executive privilege claims. Second, this creates a massive credibility problem for the Justice Department at a time when public trust in federal institutions is already at historic lows. A poll conducted on February 6th found that 71% of Americans believe federal agencies should not be allowed to surveil members of Congress investigating potential government misconduct, with strong majorities among both Republicans and Democrats agreeing on that principle. When you lose public confidence that oversight actually works because the agencies being investigated can monitor and potentially intimidate the investigators, you've fundamentally broken the accountability mechanisms that prevent corruption and abuse of power. That's not a Democratic issue or a Republican issue. That's a systemic crisis that threatens the legitimacy of government institutions across the board. Finally, looking at the broader implications, this scandal raises serious questions about what else the DOJ might be monitoring that we don't know about yet. If they implemented secret surveillance of congressional Epstein searches, what other topics have triggered monitoring programs? Are there tracking systems for lawmakers investigating Hunter Biden January 6th prosecutions, FBI informant use, or classified document handling? The leaked memo suggests the Congressional Access Accountability Initiative covered multiple databases and topics, which means Epstein was just one piece of a much larger surveillance apparatus. And if that's true, we're not talking about an isolated incident of poor judgment. We're talking about a systematic effort by the executive branch to gather intelligence on legislative oversight activities across a wide range of sensitive matters. Drop a comment below with your thoughts, because I'm genuinely curious about your perspective on this situation. But beyond the immediate immediate scandal and political fallout. This is really about fundamental constitutional principles that Americans of all political persuasions should care deeply about. The separation of powers isn't just an abstract concept from civics class. It's the mechanism that prevents any single branch of government from accumulating the kind of unchecked authority that inevitably leads to tyranny. When the executive branch can surveil legislators investigating executive branch misconduct, you've created a system where oversight becomes performative theater rather than genuine accountability. And once that dynamic takes hold, there's no realistic way to prevent abuses of power because the people responsible for exposing those abuses know they're being watched. And here's what should alarm everyone, regardless of party affiliation. This isn't just about the current Justice Department or the current Congress or even the Epstein case specifically. It's about whether we accept as normal that federal agencies can secretly monitor elected representatives doing their constitutional jobs. If there are no serious consequences for DOJ officials who implemented these surveillance programs, it establishes a precedent that executive branch agencies can gather political intelligence on legislators with impunity. The next administration will push boundaries further. The administration after that will expand monitoring systems even more. And within a generation, the separation of powers becomes a historical artifact rather than a living restraint on government overreach. Pause for a second and hit that like button if you're finding value in this coverage. Now, here's what makes Speaker Johnson's response so significant in this moment. Johnson isn't some firebrand conservative looking to score political points against the Biden administration. He's a relatively moderate institutionalist who has consistently prioritized bipartisan cooperation and respect for constitutional norms. When someone with that temperament and track record says the DOJ crossed a line that cannot be defended, it signals that this scandal transcends normal partisan divisions. Johnson stated in a February 7th interview that he's received private calls from Democratic members of Congress equally outraged by the surveillance program, and he expects the upcoming hearings to reveal the full scope of DOJ monitoring activities that most Americans would find deeply troubling regardless of their political views. Meanwhile, sources inside the Justice Department are reportedly panicking about the political and legal fallout from this scandal. According to leaks to multiple news outlets, senior DOJ officials held emergency meetings on February 5th and 6th to coordinate their response to congressional demands for information. Some officials allegedly argued for full transparency and cooperation, acknowledging that the surveillance programs were constitutionally indefensible and hoping that candor might limit the damage. Others insisted on fighting congressional subpoenas by claiming executive privilege and arguing that oversight of DOJ security protocols would compromise sensitive law enforcement operations. The internal division reflects a broader crisis within the department about whether institutional credibility can survive this scandal or whether the political damage is already irreversible. And here's where things get absolutely wild in terms of public reaction. Social media exploded with outrage from across the political spectrum when news of the DOJ surveillance broke. Liberals who typically defend Justice Department independence against Republican criticism are posting that monitoring congressional Epstein searches is indefensible and smacks of authoritarian behavior. Conservatives who have long argued that federal agencies are weaponized against oversight see this as vindication of their concerns about the deep state. Libertarians are pointing to the surveillance as proof that government power will always expand beyond constitutional limits without serious structural reform. When you unite the left, right, and center in opposition to government conduct, you know something genuinely outrageous just surfaced. But here's something even more disturbing that's starting to emerge from additional whistleblower testimony. According to sources who spoke to investigative reporters on February 8th, the DOJ surveillance program didn't just passively monitor congressional searches. In at least 3 documented cases, senior Justice Department officials allegedly used the tracking data to preemptively brief media contacts about upcoming congressional inquiries, attempting to shape public perception before lawmakers could release their findings. One specific example involves a House member who extensively searched Epstein files related to the 2008 non-prosecution agreement in November 2024. Within 72 hours of those searches, according to the Whistleblower account, Favorable stories about the DOJ's handling of the Epstein case appeared in major news outlets, citing anonymous Justice Department sources who defended the agreement as legally sound and properly executed. Think about the implications of that for a moment. If the Justice Department can see what Congress members are investigating in real time, they can get ahead of oversight efforts by laundering their preferred narrative through friendly media contacts before the congressional investigation even produces results. That doesn't just chill oversight, it weaponizes advanced knowledge of oversight to neutralize its effectiveness before it can impact public opinion. A former congressional investigator with 18 years of experience told reporters that if these allegations are true, it represents a level of executive branch manipulation that makes Watergate look like amateur hour. At least with Watergate, Nixon was reacting to investigations after they became public. This is preemptive strike capability based on surveillance of what Congress members are looking at in classified databases. And here's another angle that legal experts are starting to examine more closely. Several constitutional scholars have pointed out that the DOJ surveillance program potentially violates the Fourth Amendment rights of members of Congress. While the Fourth Amendment is typically discussed in the context of criminal investigations and warrants, it also protects against unreasonable searches of private information. When Justice Department officials systematically track and analyze the database searches of elected representatives without their knowledge or consent, that constitutes a search of their investigative activities and intellectual work product. A University of Chicago law professor told reporters on February 9th that members of Congress could potentially file suit arguing that DOJ violated their Fourth Amendment rights by conducting warrantless surveillance of their legislative research activities, which could open up an entirely new legal front in this constitutional battle. Stay with me because what comes next will completely change how you view government accountability. On February 8th, 3 members of the Senate Judiciary Committee sent their own letter to Attorney General Garland demanding answers about the surveillance programs and announcing that they would block confirmation of any DOJ nominees until they receive satisfactory explanations. The letter, signed by 2 Republicans and 1 Democrat, states that the Senate cannot fulfill its advice and consent responsibilities if the executive branch is secretly monitoring legislative oversight activities. This bipartisan Senate pushback is significant because it shows that concern about DOJ surveillance isn't limited to House Republicans with political axes to grind. It's shared by senators from both parties who recognize that allowing this conduct to stand without consequences would fundamentally alter the constitutional relationship between Congress and the executive branch. Legal experts are already predicting that this scandal could trigger court battles that reshape separation of powers jurisprudence for decades. A Georgetown law professor told reporters on February 9th that if members of Congress sue the Justice Department over the surveillance programs, federal courts will be forced to address questions about the scope of executive power that have remained largely theoretical until now. Can the executive branch monitor legislative oversight activities in the name of security? Do members of Congress have any legal recourse when federal agencies surveil their investigative work? How far does the speech or debate clause extend in protecting lawmakers from executive intimidation? These aren't abstract academic questions anymore. They're live controversies that could determine whether separation of powers remains a meaningful constraint on government behavior or becomes a quaint historical relic that officials ignore whenever convenient. If this blows your mind, hit that like button right now because we're not done yet. Here's the situation as it stands right now. The Department of Justice got caught secretly tracking which members of Congress searched Jeffrey Epstein files, creating profiles on 23 different lawmakers, and sharing surveillance reports with senior officials every 2 weeks. Speaker Mike Johnson, one of the most institutionally minded Republicans in Congress, called it unconstitutional and announced immediate hearings. Constitutional scholars from across the political spectrum agree that executive branch surveillance of legislative oversight activities violates fundamental separation of powers principles, and senators from both parties are now blocking DOJ nominees until they get answers about the full scope of these monitoring programs. This isn't another news cycle that fades after a few days. This is a genuine constitutional crisis that will define the boundaries of executive power and congressional oversight for years to come. If there are no serious consequences for the DOJ officials who implemented these surveillance systems, it sends an unmistakable message that federal agencies can intimidate and monitor legislators investigating government misconduct without facing any real accountability. That precedent doesn't just affect the Epstein case or this particular Justice Department. It reshapes the entire dynamic between Congress and the executive branch in ways that fundamentally undermine democratic accountability. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand as of right now. Congressional hearings begin February 10th with DOJ officials under oath testifying about who authorized the surveillance programs and what legal justification they claim. More whistleblowers are reportedly coming forward with evidence of additional monitoring systems beyond what the initial leaked memo revealed. And legal teams are preparing potential lawsuits that could force federal courts to clarify the constitutional limits on executive branch surveillance of Congress. The stakes could not be higher, the evidence could not be more damning, and the implications for separation of powers could not be more immediate. What happens next in these hearings will determine whether members of Congress can investigate executive branch misconduct without fear of retaliation and surveillance, or whether federal agencies have effectively neutered legislative oversight by turning it into a monitored activity subject to executive control. The Constitution established 3 co-equal branches of government precisely to prevent this kind of executive overreach. If we allow it to stand, we've abandoned the foundational principle that made American democracy different from the European monarchies our founders rejected. This is the moment, this is the test, and this is when we find out whether constitutional boundaries still mean anything at all. Keep watching this story closely because what happens next will shape the future of government accountability in America.